on the chairman's to-do list.
Let's see, this microphone works.
First of all, we have Spectrum. They just got done with the AWS-3 auction. They raised an incredible over $40 billion for Spectrum that wasn't prime. Next year, though, about a year from now, will be the auctions of the broadcast spectrum. If you are a mobile wireless provider, this is sort of the World Series of auctions, and it will be incredibly complex. There's a reverse auction for the broadcasters to get rid of their spectrum, and then a forward auction for mobile providers to bid on that. And there'll be a lot of rules and decisions coming out during the year on how those auctions will be held. First thing. Second thing, Ross put up here, mergers. Comcast, Time Warner, Charter, AT&T, DirecTV. You may have seen the other day they stopped the clock on their review of the mergers. A year ago, when we're looking at especially the Comcast Time Warner deal, 90-10 it would have happened. I think the odds have dropped quite a bit, and so it's getting much more interesting about actually what's going to happen. We have over-the-top programming issues, and the FCC trying to figure out how to ensure those over-the-top programmers, which seems like everybody these days, every week we get somebody else starting a new over-the-top series, bundle. Will they have any rights and obligations? We have the tech transitions proceeding, moving from TDM to IP, copper to fiber. Bunches of issues were thrown into this one. And by the way, we'll talk more about all of these. I'm going to just quickly give a list. On that, Ross mentioned the battery backup issue for CPE. There is also the issue about providers who are moving from copper to fiber, maybe having extra obligations of providing notice and other opportunities for consumers to participate in that process. Something that sort of boggles the mind, but we'll figure that one out. And then finally, key issue for a lot of people here, the Connect America Fund. And particularly on the rate of return side, whether the FCC will finally get to new rules on how that fund is going to transition. And then on the price cap side, we're about to give the price cap carriers a right of first refusal, and then there will be auctions, competitive bidding in a year for the areas they don't take. That's a pretty full year.
What we've done is we've provided a bit of slides. I'm going to have Barbara come up here and walk you through what this order says and what it means for you. So with that, Barbara.
Good afternoon. Can you all hear me? Good deal. Whoops, I went wrong. Ross.
Yeah.
Which is the Okay, we're going to give you a first look here because and say right off, it was a massive document that the commission put out, total of 400 pages with dissenting opinions and other parts to it. It was adopted on February 26th, released about 2 weeks later. It was a 3-2 party line vote, 3 Democrats for, 2 Republicans against. The document itself, it's actually comprised of 3 separate actions. There's an order on remand, and that first part of the decision adopts what everyone calls the net neutrality. There was a second part to it, a declaratory ruling that reclassifies broadband internet access service from a lightly regulated information service to a Title II telecommunications service. And then there's a totally separate order that addresses forbearance from Title II provisions that the Commission felt were unnecessary to apply in light of their other rules and the fact that heretofore broadband internet access service had not been treated as a common carrier service. The Chairman Wheeler said that this is a modern, light touch Title II. I will let you be the judge of that after we go through what the Commission has done here. The decision will take effect 60 days after publication of the order in the Federal Register. That could still take several more weeks. There is one exception. The Commission adopted enhancements to the 2010 transparency rules, and those enhancements cannot go into effect until the Office of Management and Budget approves this additional paperwork burden. And there is a temporary exemption for ISPs serving 100,000 or fewer subscribers from having to comply with the enhancements to the transparency rule when they do go into effect. And the Commission will make a decision on that by December 15th this year. The scope of the order is quite broad. Unlike in 2010, it applies the exact same set of rules to both fixed and mobile broadband internet access service. That service is still defined as a service that allows users to reach all or virtually all endpoints on the internet. The order on remand adopted what the Commission is calling 3 bright line net neutrality rules and then a general internet conduct standard. Totally new idea. It was not put in the notice of proposed rulemaking. The Commission relies on all of its available legal authority to adopt these rules. Title II, Title III, Section 706. As I said earlier, it reclassified the service, telecom service. And it applies on 21 out of 48 provisions of Title II. And the provisions that do apply include what are referred to as the core common carrier protection, Section 201, Section 202, related enforcement authority under Section 208. There is forbearance from rate regulation applied before the fact. So the Commission will be relying on the complaint process and investigations into your rates, but it will not be setting rates, and significantly, it will not be requiring you to file tariffs. And the 3 bright line net neutrality rules will prohibit a broadband internet access service provider, who I will refer to after this as an ISP for simplicity's sake, from engaging in blocking, throttling, or pay prioritization. These rules are based on conduct that the Commission said it already knows harm internet openness. It finds that each of these practices are inherently unjust and unreasonable. That is the Section 201 standard, and therefore they're deemed to violate Section 201B of the Communications Act as a per se matter. They also violate the Commission's understanding of Section 706. An ISP is prohibited from blocking lawful internet content application services or non-harmful devices subject to reasonable network management. This is basically the same rule that was adopted in 2010 that was vacated by the Verizon court. It's been readopted. You're also prohibited from charging an internet edge provider, and by edge provider, I mean an internet content service application or device provider, from paying you to unblock their transmission. The Commission adopted a rule also that was not in the notice of proposed rulemaking. It's called no throttling. And throttling is impairing or degrading lawful internet traffic on the basis of internet content, applications, or service, or the use of a non-harmful device, subject to reasonable network management. What it addresses is ISP-initiated targeted impairment or degrading of certain traffic, but not any slowing of internet traffic that your end user has asked you to do. You might have a service plan where they agree to have less broadband available at certain times, and that's okay. But it's ISP-initiated throttling that's prohibited, and the commission will review your data plans pursuant to the General Internet Conduct Standard and your disclosures about such plans to determine they're just and reasonable under the transparency rule. The third bright line rule is the no paid prioritization rule. This bans a practice that was virtually unknown to exist in the marketplace that caused extreme consternation among the public, and that would be favoring some internet traffic over another on your last mile network in exchange for consideration or to benefit an affiliated entity. The commission said you could get a waiver from this rule, but it said it would be virtually impossible for it to grant one. So I would say that this rule is a flat prohibition. It'd be very unlikely that you could go in and make a case that you ought to be able to engage in that conduct, even if you wanted to. Not clear why you want to do that. I think the most troubling part of this part of the decision was the adoption of this general internet conduct standard. Again, this was something the commission gave the public no notice that it was going to consider adopting. And what it does is that it prohibits an ISP from unreasonably interfering or unreasonably disadvantaging the ability of both consumers and edge providers. For consumers, is to select access or use lawful content application service of their choosing, and with respect to edge providers, is to make lawful content application services or devices available to consumers. This is based on the Commission's concern that there's conduct that they don't know about today, but you have the tools to engage in. You have the tools to degrade and deceive your consumers and the public, and it needs some general standard of conduct so that it can be the referee on the field, and as the chairman say, throw the flag if you do something the commission decides is in violation of this general internet conduct standard. It is an incredibly broad brush standard, and this will be enforced on a case-by-case basis. You will not know in advance until we get some case law under our belt exactly how the commission is going to apply this rule. It does represent their interpretation of section 201, 202, section 706, that this type of behavior would be unjust and unreasonable and possibly unreasonably discriminatory. In judging your internet conduct, they will apply a totality of the circumstances test. And the order lists 7 factors, they're up on the slide, that the commission will take into account in judging your behavior, but this is not an exclusive list. Other factors could come up. I think some of them were troubling ones from the perspective of how are you supposed to conduct your business in conformity with what the commission wants, is that you can't degrade and inhibit free expression of consumers and edge providers. In other words, free speech. I'm still trying to decide in my own mind, well, what do they mean by that? What could you possibly do? Also, competitive effects. You can't favor your affiliated services. This process will be reviewed, as I said, to review your data plans, your data allowances and caps, your usage-based pricing, to see if you are using any of these things to degrade or inhibit internet traffic and free expression. The reasonable network management qualification that was in place in 2010 still applies, but it applies only to the no blocking and no throttling rules, not the ban on paid prioritization, which is a flat ban. And in applying this, the commission will look at what type of network do you have. Is it DSL? Is it fiber? Is it mobile? Is it fixed? And make a determination whether what you're doing is reasonable network management or whether you are in fact manipulating reason rather than a technical network operation reason. This is a significant tightening of the standard that applied in 2010. The Commission has retained the exemption from these open internet rules for what used to be called specialized or managed services. They're now called non-broadband internet access data services. And the scope of this is tightened to ensure that you're not trying to end run these net neutrality rules by having some internet access service on the side that is called something else but functions in the same way. The next area that's contained in the order on remand is the part on the transparency rules. And the Verizon decision left intact the 2010 transparency rule. You should all be reviewing your current net neutrality disclosures to ensure that you are in compliance with that rule, because the FCC is very serious about enforcement activity right now. And although the enhancements do not yet apply, you should become familiar with them and take them into account if you're updating your disclosures. They must be both accurate and up to date. It's an ongoing obligation. So the enhancements that were adopted were to ensure greater transparency of specific conduct by ISPs that might harm the open internet. And they've outlined 3 areas where just enhanced disclosures are required. That is, if you are not in the exempt category right now. And basically, I'm going to go quickly through these in the interest of time. Commercial terms must be disclosed now, but they've added what must be disclosed. If you have a promotion, you have to now disclose what the rate will be at the end of the promotion. All your other fees in connection with service must now be disclosed, including any cable modem rental fees, early termination fees, installation fees, all information about data gaps and allowances if you're using them. No. The next area is performance characteristics. Again, this is an area where you're currently under a disclosure obligation, but now you have to describe packet loss on your system and performance characteristics on a geographic basis and both over a reasonable period of time and during peak usage. It's an extraordinarily burdensome requirement. You have to disclose the impact of a non-broadband internet access service on your internet service. The one thing they didn't do, which they had proposed in the notice, was disclosures regarding network congestion. Fortunately, that is not part of the obligation. With regard to your network practices that you are already required to disclose, you have to disclose with more granularity any user and application-based network management that you're using that could basically affect the user experience. Again, they didn't go as far as they said they would. There is no disclosure of application-specific usage or how a particular user device contributes to their total usage. They had proposed even worse rules than were adopted here. So this is one of the few brighter spots of the order. This is by far the brightest spot of the order. ACA pushed really hard to get small providers exempt from all transparency enhancements. And I think we're the only group that got any kind of carve out in any respect from any of these rules. I call this a folding chair because it's a temporary partial exemption, but it was incredibly hard to get this, and we will fight really hard to have it preserved. Basically, you don't have to comply with the enhancements I just went over. You have 100,000 or fewer subscribers. They delegated authority to their Consumer and Governmental Affairs Bureau to determine by December 15th, do we keep this exemption? Is 100,000 the right number? Should it go up? Should it go down? Again, you still have to disclose everything you have to disclose as of 2010 rules. Another area where they didn't go as far as they were planning to was to require 2 sets of disclosures. Right now, you can have a unitary set of disclosures. It's to disclose to your end users and network edge and internet edge providers all of this information. They said, okay, well, we're not going to force you to have two sets of disclosures, but make sure that if you're using a unitary set of disclosures, they're adequate for both purposes. They are going to develop a voluntary form of disclosure for the end user disclosures to be developed by the Consumer Advisory Committee. If you use that form, you could still be liable for a violation of the transparency rule if the information you put on it is not accurate. So it's a partial safe harbor, but if you use that form, you will need a separate set of disclosures for internet edge providers because the form will only apply to end user disclosure. One of the startling parts of the order on remand is that the FCC has asserted jurisdiction for the first time over internet traffic exchange, interconnection, peering, transiting agreements that you as an ISP have with other network providers. What the Commission has done is to say those arrangements have become part of your retail broadband internet access service, because when you hold yourself out to the public to provide that service, you're implicitly promising you will make all internet interconnection arrangements necessary to provide that. I don't know how to describe that as almost like an act of transubstantiation. They've taken your retail service and they've taken what had been a wholesale upstream service and they've now made them one item. The FCC will entertain complaints and take appropriate enforcement action on a case-by-case basis. If a complaint comes in and it determines you did not have enough network capacity to provide to your consumers the service you have promised, it's potentially a very intrusive new part of the open internet rules, and we'll have to keep an eye on how that develops. The second major part of the document was a declaratory ruling changing the regulatory classification